The Supreme Court handed down the Clay decision, which essentially removes the Voting Rights Act as a thing that we can use to drive racial discrimination lawsuits in federal courts. Chris Fowler, professor of geography and demography at Penn State University. It no longer functions. That what the justices have called the updated jingles requirements are updated in a way that they're essentially impossible to meet. You have to prove that, on the one hand, you could have drawn a map that preserved voting rights for Black communities without giving up a single one of the state's other priorities. You also have to prove that the same map couldn't have been achieved in an attempt to achieve partisan advantage. So the reason this is a problem is because party and race are highly correlated, particularly in the South. And in that context, anything that could be racial could also be partisan. Anything that's partisan could also be racial. You actually cannot distinguish between the two. So the jingles requirements rewritten in this decision essentially make it impossible to bring any kind of claim under the Voting Rights Act. And it's tragic because we have this very particular form of geographic congressional district because when the Founding Fathers set out the Constitution, they thought the communities of interest would be a good way of electing officials, that we with our neighbors, whatever differences we might have, could come to some agreement because we shared proximity to one another, we shared community with one another. And what we have here is an increasingly intense insertion of partisan goals on top of that, and to replace that, so that the community of interest is no longer the target, partisan advantage is the target. And so by going down this path where first we sustained that partisan advantage is not justiciable in federal court, this is a decision that goes back a couple decades now. Once you say that partisan advantage isn't a thing that can be dealt with in court, suddenly you have a free-for-all. And as long as you're doing something for partisan advantage, you're allowed to do it under the Supreme Court. You really can't have any claims under the Voting Rights Act anymore. And it's tragic. It's basically let this one way of breaking our geographic system of representation to gain partisan advantage, it's let that be the main way we draw districts. And essentially we've said our democracy is in the hands of these parties, and we, the people, have nothing further to say about it. So this gets problematic because, of course, the way we could get a remedy is from Congress. And if Congress is dominated by these parties have serving their self-interest, they're not going to pass laws that constrain their own capacity to act. And so, yes, we should expect to see parties in power redrawing to the extent that they're capable. And with current GIS technology and mapping technologies, they're capable of quite a lot. We used to see redistricting every 10 years. With new technology, I could step over there and draw you 1,000 maps within 5 minutes. It's easily done. I can optimize them on whatever criteria I want. There's lots of things I can do that we couldn't do even 10 years ago. So the technology is there to draw maps really quickly, and the guardrails are completely off. We can draw maps essentially whenever we want, to whatever end we want, as long as it looks like partisan advantage could be an explaining variable.